Granby, pressing on those brakes. This is the result of the defendant speeding through Fraser, Bursid, Idaho Springs, pressing on that brake, heating them up. This, members of the jury, this is the result of the defendant pulling. Now, this is the result of the defendant having 6 miles, members of the jury, after the runaway truck ram and doing nothing to try and put a stop or even slow down that truck. This is the result of the defendant actively swerving into a sea of traffic. This is the result of the defendant doing anything but caring about others that were on the road that day. This is the result of the defendant driving carelessly, acting recklessly, acting with extreme indifference. This is the result of what this case comes down to. Bad decisions. The defendant made bad decisions that caused his brakes to go out. And then he made more bad decisions when he had the opportunity to prevent this, to put a stop to this. But he says he did nothing wrong. Now, in this case, we as the prosecution, we have the burden of proof. We have the burden to prove beyond a reasonable doubt every element of all the charges. We've done just that. But let's talk about what this burden of proof looks like. It's important to note that beyond a reasonable doubt isn't beyond all possible doubt or beyond a shadow of a doubt, because that would be impossible to prove. But that's why the standard is beyond a reasonable doubt. And as Mr. Maritzky talked to you about in voir dire, reasonable doubt is based on reason and common sense that arises from a fair and rational consideration of the evidence. Now, reasonable doubt is not vague, it's not speculative, and it's not imaginary. And I want you to remember that when you think about what the defense is asking you to look at. Now, I told you that we have to prove all these charges in each and every element beyond a reasonable doubt. Let's actually look at those charges. The first charge is assault in the first degree. Now, there's 6 elements here, and I want to walk through these elements, what they look like, and how we've proven them. 1, that's a defendant. We know it was the defendant. 2, in the state of Colorado, this accident or this crash happened in the state of Colorado. And 3, knowingly. Well, let's look at what knowingly means. Knowingly is based on conduct and a result. It's a person acts knowingly with respect to conduct when he's aware that his conduct is such of nature or such a circumstance exists. And when it's a result, it's that the result of his conduct when he's aware that his conduct is practically certain to cause the result. Members of the jury, we've all driven a car. Everyone in this room's driven a car, and you know the dangers that exist with driving that car. And you know that that danger increases when you're driving a massive semi-truck anywhere, but especially the mountains. There's no one in this room that wouldn't say that that semi-truck and the way the defendant was driving it that day, that he knew that he was practically certain that death or injury could occur from that. The defendant knew. He was practically certain that those results would occur. Now, defense might come up here and they might tell you that, well, he didn't know what he was doing because he was inexperienced. Well, Members of the jury, he has a lot more experience than he wants you to believe. He's worked for 4 or 5 different companies before this. In fact, on the stand, he actually pointed out he knew the differences between the 2018 CDL manual and the 2019 CDL manual. He's a CDL holder. He took the test. He passed it. And he's held to those rules. And he knows. He knows how dangerous this is. Common sense tells us how dangerous this is. Now, next we get to under circumstances manifesting extreme indifference to the value of human life. I want to walk through what this is and what this means for this case. Now, extreme indifference, when we look at this, it's when you're looking at, I guess first let's just look at careless driving. You're going to hear about careless driving, and this is when you back into someone at Safeway. That's careless driving. And then reckless driving is something like when you're weaving and you're speeding on the highway and you hit someone. But extreme indifference is when you have reckless acts that stack on top of each other. And they stack and they stack. And it becomes so reckless that it becomes extreme indifference. Well, let's look at all those things, all those reckless acts that stack up on each other and become extreme indifference to human life. First bad decision. Members of the jury, I want to be clear. This case does not center around the crash and at the bottom of that hill. This starts all the way back. This starts all the way back to when the defendant started his career. He started with Ferguson Fire. He was a technician there. He was a fabrication technician doing piping. Then he goes to Labatt, and he says on his application that he's a driver when he was never a driver for Ferguson Fire. And it doesn't stop there. Then he goes to GMP, and he says, oh yeah, I was a driver at Ferguson Fire. Even though you heard from Jose Hurtado, he was never a driver. The defendant himself, he admitted he was never a driver. And the defendant himself admitted that he did that only to get a job. He knew he wouldn't get this job otherwise. Members of the jury, make no mistake, this is not an accident that he ended up here. It's not. He put himself here. Those employers, they relied on what he was saying. The companies, they look for this experience. They look for it for a reason, and that's why he knew he wasn't going to get the job. And some of you may be wondering, why didn't he get more training? Why was he put on the road if he didn't get training? This is why. This is why. Because he put on there that he represented that he had this experience. Members of the jury, that's reckless. And that's arguably alone extreme indifference. It's dangerous to get behind a semi and then to tell people that you have experience when you don't. That's saying you do not care about the safety of others. Let's keep going. Next bad decision. Now this starts with all these pre-trip inspections that the defendant is supposed to do. Legally, he's supposed to do. He's required to inspect, and he has to know how to do this. Now, I want to think about these brakes. It's, both sides agree that these brakes were out of adjustment. Defense experts told you that. Jared Steele told you that they were out of adjustment. But let's look at the 2 possibilities as to how that happened. First possibility is that they were that way, and the defendant didn't do an adequate pre-trip inspection, or he didn't do one at all. That's reckless. Defense is going to try and tell you that he got this car, that it was defective, and that it's Tomas Roque's fault. It's Edwin Andrade's fault, the people who worked on the truck. But it's the defendant's job. He's required to know how to inspect that truck to make sure it's safe. And he wouldn't have caught that if he didn't do an adequate pre-trip inspection. That's one option. Second option is that, Okay, fine, we'll give him the benefit of the doubt that he did the pre-trip inspection. But the brakes were that way. And you heard Jared Steele that the way that they get that way, with that large gap that they were explaining in the shoe and the pad, is from overuse. So there's only two ways this can go. It's either the defendant didn't catch it and he was supposed to, and that's reckless, or the defendant drove on his brakes the entire way and caused them to be that way. That's reckless. Now, I want to pause for a moment and talk about the difference between what you heard from Jared Steele and what you heard from the defense experts. Jared Steele, he has a CDL, and he explained to you that he factored in the entire case. He factored in the fact that the defendant should have caught these things in pre-trip inspection. The defense experts didn't consider any of this. They just assumed that he did everything right, and this was their opinion. Next bad decision, took the more dangerous route. When he took that stand, and I asked him, you took this because gas was cheaper. He said, no, Rafael told me. Rafael told me to do this. Even though I confronted him with what he told the police the first time. It's the question specifically. You can go back and you can look at that transcript. It says, why 40? Why US 40? And he says, well, I took it. I was taking 40 because I was trying to get to I-70 because gas is cheaper. He didn't tell police because Rafael told me to do it. That's just the story when he took the stand. He's taken this route before. That was very clear. He said it at least 5 different times to the police. But think about the fact that he had GPS, so he never even needed to ask Rafael if that's what he wants to go with. He could have figured out which way to take. But I want to pause for a moment and I want to talk about what the defendant told you when he said that Rafael told him not to take I-25, because that was completely out of context. You heard Rafael Rodriguez take the stand. Was that the defendant was already on I-70. 25. Don't take I-25 because of the timing here is important, because this is after trouble with his brakes. Trying to tell him when he was take. And that's just speeding brakes. And now they're starting to heat up. Dude, you heard Yami, she said that. To make up time. Stand. Defense counsel turned out in front of you. The stand. Those two. And Dawn Hull, man, she even absolutely, I would. Flew by, and he nearly. Next bad decision. Brakes. You can go look at that in evidence. Who has worked at that U-Haul going really to run. We're going to talk about birthed past here. Birthed past is, as you steep. And it's less dangerous. Really dangerous. Look at Danny Simpson's test. See, those were, and was up near the bottom. And the defendant passed. His brother. And other calls from Antonio, you don't see a call from Raphael until told you that when he pulled over, he had a good enough signal that he was. But this is not a cell phone fail until he was already gone. Now, the stand, Henderson Mine, pulled over with the brake smoking. But he's wrong. The defendant says, well, I guess I'll check my brakes. That they were lukewarm. Which I pointed out with him, well, doesn't, because they're been working. If they were warm because of the friction. The story. Now we know that it is more likely he pulled up, he saw the brake smoking. Why would the defendant, two people with his brakes? Ross told you exactly what happened. He said the defendant had to go through all of this, and then he called to walk him through it, but he had said that his brother. That is what happened. Going down Berthoud fast. Brakes. It's a steep downhill. But what Jared still told you, the defendant climbed and he kept driving. That is arguable that these brakes aren't working. You don't care. So you get back in your truck and you keep driving. Obvious, he was going over the hill too fast. It was consistent that he was going 55 miles. But notice how that changed 20 miles per hour. With his Jake brake on. Fish. Defense expert. Every expert told you that who took the stand told you he passed him going up the hill at 70. Generous by saying it's 50. said 55 miles here. That tell you CDL manual tells you. And select grade. And the defendant knew this. He talked all about it. Actually, if you don't pick the right speed, the hill. Place was what? 6, and he was going 55. 55. Going 55. Takes the stand 35 miles per hour. The only defense 6 is their own. It is paramount to be and to depends. Be in the right gear. And again, we have the CDL that tells are important. Select the right gear. Shift after the shift into a lower gear. Knew the CDL requirements. Brake. Brakes went out. Shift out of gear when you flat hill. Doesn't stop there, members of the jury. Ramp. And up and talk about how he's given 370. That is well past driving the way he was in Pedro Olvera. With defense, he Hill. And I ask him, okay, yeah, now suddenly go through all these signs that he sees. He says is 1.5 miles. It's 3/4 of a mile. I'm like, oh, you see the third sign. Back and forth, back and forth, back. He knew exactly where everything happened. Asked him questions he didn't know where anything was or what any. Then he says, in the second two signs, 200 feet between these signs. Hill. Members of the jury, there is no hill there. Then God, he saw those first two signs. Pedro Olvera's video, he's looking and he says, ramp, passes right past it. Members of the jury, defense and didn't see that ramp. He was looking down at his shifter. But what he did, he looked at it and he said, I can get this down. It. And it's not until he sees the oh crap, I can't. Is when Brett Dickerson, who took the stand, well, yeah, he was panicked because he now realized he made a choice. That. He was thinking about the rig. He was thinking about keeping next place. He was thinking about himself. Now, you heard John Dahl take this. Trucks can take it halfway through. It's 0.6 of a mile long, and you can take it. And it said he looked right, and he looked left. There's if you look right, there are no. The runaway ramp. He saw it. He didn't take it. Now, the CDL requires you to know these things, right? And he said, oh, no. The 2019 manual, the 2018 manual. He knows that manual so well. Of them. 6 miles. Members of the jury, he had 6 to do anything. He didn't do. He didn't. And if you go back and you watch, I want you to all of the places. But because he didn't realize that he traffic. Me took the stand and told you that there was traffic up at Ward Road. The CDL manual tells you exactly what to do. If there's no escape ramp, will take the least hazardous escape route you can, such as an open field or a side road. The defendant doesn't do that. Many people took the stand and said, no, there was no attempt that he made to try and stop this thing. He didn't care about the other people on the road. He cared about himself. Next bad decision. And this is the ultimate bad decision. One of you asked, what path did he take? Members of the jury, the defendant got up there and he told you, well, I was thinking of doing this, but this would happen. I was thinking of doing this, but this would happen. But I was thinking of doing this, but this would happen. He was all the way in the left lane, swerved all the way over to the shoulder. He saw Doug Rowe in that beauty mattress truck pulled off. He came up on that truck and he thought, if I hit that truck, I'm going to die. So then he swerved into traffic. He's talking about all these places where he's like, I don't want this person to die. I don't want this person to be hurt. But then he picks the choice where he 100% knows that people are going to be hit, they're going to die, and they're going to be hurt. Swerves into traffic, and if you notice this path, he avoids all the semi-trucks. He knows that if he runs into Douglas Rowe, that he'll die. So he chooses the smaller cars, where he knows he's not going to die, and takes that path right through, barely clipped Mr. Hernandez-Chacón's truck. He swerved into a sea of cars that were sitting ducked with nowhere to go. What else was going to happen except for death or people being injured? Brian Dickey, he took the stand. Defense counsel got up here and gave the defendant's exact situation. If this goes out, if this goes out, if this goes out. You've never been in this situation. And Brian Dickey said, I know one thing. I would have never swerved into traffic. And lastly, the defendant, he could have stopped and he could have helped other people because that's what everyone else did. You heard Christina Ryan, she took the stand, she said, me and this other guy, we actually went to go look to make sure the defendant was okay. But he was already gone. They went to go check on the person that caused all of this. The defendant was long gone. And he tried to tell you this story on the stand that he wanted to go help, but this other person was forcing him to not go help because his knee hurt. Darren Barton, the man that was panhandling at the top, as he's running down to go save people, the defendant's running up to get away. He was knocking on doors asking for phones so that his brother could come pick him up so he can leave. And he said, I'm going to jail. Because he knew what he did was wrong. He told you on the stand yesterday, he said, Dear God, the last thing that was going through my head was, Dear God, don't let anything bad happen. But then in his interview with police, he didn't ask about anyone in that interview. He didn't ask if anyone is okay. Surely he knew that someone got injured, that someone probably died. The CDL, it tells you what you do when you get in an accident. Notify the authorities and you care for the injured. The last person he called was Raphael. He didn't call the police. Members of the jury, where do I even start with this one? Falsified logs. All over the place. You heard from Miles McDowell that he didn't even have this plugged in, and he was doing this intentionally. He knew that because a banner pops up that tells you have to connect. And you can hit connect. And it's this platform. It's in Spanish. It's in English. Regardless, he knows. Brandy Hurley told you that he's never seen anything like this. That he was just changing these left and right, and that he was doing this to circumvent the rules. He told you that these rules, they exist for safety, because large crashes can happen when we can't track people's hours, if they're driving for too long. Members of the jury, the defendant didn't want to be tracked. He wanted to go faster. He wanted to go longer. And so he changed those logs. He had that thing unplugged so no one could track him. And he tried to tell you that Raphael made him do it. That Raphael was the one telling him to put in. Well, what about the 25th when he was by himself and all those logs were changed? Come on. He wanted to do what he wanted to do, and he wasn't caring about anyone else. That's reckless. That's extreme indifference. Now, next you look at engaged in conduct which created a grave risk of death to another person. We know that. We just went through all of that. All of that conduct created a grave risk of death to another person and thereby caused serious bodily injury to that person. Serious bodily injury, what you need to know or pull out of that definition, is a substantial risk of serious permanent disfigurement and breaks or fractures, because that's what we have here with the 2 SBI victims. And these are the people that you will consider, and you will see this in your jury instructions. There's 4 people that have death. And again, serious bodily injury, that assumes death. But you also heard from Dawn Holmes that these people died from blunt force trauma. Alex LaGuardia, she took the stand and she told you that every day she looks at that scar, she remembers what happened that day. And Leslie Ross, who broke her arm. Now, when we look at attempted assault in the first degree, it's the exact same elements as assault in the first degree. The difference, though, is that it was a substantial step. Substantial step is that, is there any conduct, whether act, omission, or possession, which is strongly corroborative of the firmness of the actor's purpose to complete the commission of the offense? Everyone's probably thinking, what does that even mean? Who wrote this? A lawyer. A lawyer wrote this, but it's basically meaning that he took some step in order to commit the crime of assault in the first degree. members of the jury, we just went through all of those substantial steps that he took. So this has been proven. And those are all the victims that you can consider for this. So something I want to talk about is that we are not saying that the defendant intended to kill people that day. That's not the standard. That's not what I have to prove. And I'm not saying that. You all remember when Mr. Maritsky came up here and he told you about his son. And that, his son was stacking up all these things, putting the cup in his the silver in his chin, and then stacking up the soda on his plate. And then when he went down, you hear a big crash, a boom. You all agreed that he didn't intend to do that. He didn't intend to throw everything on the ground, of course not. But you also all agreed that it wasn't an accident. He knew what he was doing. And that all of those things that he did, they added up. That's how you can tell that this is extreme indifference. It's all those reckless things that add up. And they're so reckless that it's extreme indifference to human life. Then on your jury form, you will get the opportunity to decide, was there bodily injury? Was there deadly weapon? It'll walk you through which ones you can choose. Now, when we talk about deadly weapon, I'm sure most of you are thinking like a gun, a knife, like that's the normal thing you would think of. But deadly weapon's actually a lot broader than that in the legal terms. It can really be anything. It's just the manner in which it's used. This truck was absolutely a deadly weapon. It was a bomb going down the mountain. It's a bomb even when you're not driving it the way the defendant was. Everyone knows it's dangerous. But the way the defendant was using it, it was a deadly weapon. Now, vehicular homicide. 6 elements here. That the defendant, in the state of Colorado, operated a motor vehicle in a reckless manner. What does that mean? A person acts recklessly when he consciously disregards a substantial and unjustified risk that a result will occur or that a circumstance exists. Members of the jury, we have that. I just went through a gazillion examples of reckless. This is reckless at minimum. But I'd ask you to go further and say it's extreme indifference. Now, such a conduct was approximate cause. Again, another very confusing legal term. But really, this means, did the defendant cause this? Did he cause the result, the injury? Absolutely. Defense is going to try and tell you, though, that it's because that he got this truck and it was defective, and so he's not the proximate cause. This wasn't his fault. Even if you believe defense's theory, which I'm not saying you should, but even if you did, there were still so many opportunities for him to prevent this once he knew that the brakes were out. He was the cause of this and of the death of another person. Now, one thing to remember is that the term homicide, I think a lot of the ways that we think of it normally is that means murder. It doesn't mean murder. Murder implies intent. Here, again, as I mentioned, we're not talking about intent. And so I want you to keep that in mind, that homicide doesn't mean that. And these are the 4 victims you can consider for homicide, vehicular homicide. Vehicular assault. We'll touch on this quickly because it's the exact same elements as vehicular homicide. The only difference is that it was serious bodily injury, not death. And here, we heard Leslie Ross and Alex LaGuardia, and you heard Dr. Tiglier, who signed these SBI forms and told you, yes, they had serious bodily injury.
You're at 40 minutes, counsel.
Thank you. Reckless driving, again, members of the jury, this is reckless driving. It absolutely is. You can look through that and you can tell that for yourself. The defendant in the state of Colorado drove a motor vehicle in such a manner as to indicate wanton or willful disregard. That was exactly what happened here. And that's assumed with reckless in terms of vehicular homicide and vehicular assault, as well as extreme indifference. Careless driving, again, that's obvious here. I told you, reckless driving is like when you back into someone at Safeway. This is much, much more than that. So this is obviously careless driving. I want to take a moment. I want to talk to you about what defense is going to tell you and what their theory is. They're telling you everyone has it wrong, or that it's everyone else's fault, and that everything that could go wrong with the truck went wrong. All of this, all at the same time. Members of the jury, think about this for a moment. This is what this has to mean, is that all these people who saw the smoke coming from the brakes, the holes, Alan Kyleberg, all these people, they're all wrong. But they're all wrong at the same time. They're all conspiring against the defendant at the same time. They don't know each other. They don't know the defendant. While also, at the same time, everything that could go wrong with this truck went wrong. That common sense, that's not it at all. Now the defendant. Members of the jury, you can take that testimony for what that was. You get to consider credibility. There's an instruction in there that tells you specifically that you get to consider credibility. I don't remember, but he remembered everything with his attorney. Raphael told me to do it. It's Raphael's fault. I didn't know which route. Raphael told me to do it. My logs are all messed up. Raphael told me to do it. At what point is the defendant responsible for himself? Said that didn't happen. It was someone else's fault. There was an excuse for everything. He didn't do anything wrong. Every time something contrary came up, it was someone else's fault. It was someone else who told him to do it, or he changed some fact. I asked him, you drove in Colorado before? No, that's not what it is. So I confront him with what he tells the police, and it's abundantly clear. He says, yeah, the transcript says, yeah, I drove in Colorado. And then he says, no, but you're confused. Let me explain. We just drove towards the border. It was that over and over and over again. He got up on the stand and he told you that when he looked at that CDL manual, this is how it is in theory, but that's not how we do it practically. What that translates to is, I know the rules and I don't want to follow them. Defense experts. Again, you can take that testimony for what that was worth. Their opinion was no driver, regardless of experience, would have been able to safely control the tractor and trailer, and no driver would have been able to avoid the collision. But let us remember, that's a shared opinion. They copied each other's reports, word for word. And Mr. Wayne got up and still said, no, we didn't do that, even though it was word for word. But even though defense experts said, if there was a braking issue, you need to take it out of service. Knowing that people saw smoking brakes, that would have helped me form my opinion. Speed's important when you're approaching a hill. Brian Wayne told you, man, Brian Wayne couldn't even get his opinion straight. That thing changed like 5 different times. Who could keep up with that? And he kept changing it to fit their facts. But he told you 55 miles per hour is extremely at the high end of 6th gear. I didn't know he lost his brakes going uphill. That would have been good to know. You'd want to be in low gear before the hill. Members of the jury, this case, it comes down to common sense. We talked about this in jury selection, that all we are asking you to do is use your common sense. And common sense tells us this. His actions, he caused the brake failure. And that he had multiple opportunities to prevent that tragedy at the bottom of the hill, but he didn't take advantage of even just one of them. All of these decisions, common sense tells you he was the one that ran his brakes out. It wasn't some mechanical failure out of nowhere. And you know this because the last witness you heard from, Jared Steele, He talks about glazing. Now, he said he doesn't like the word glazing, but I'm using that word because I'm not an expert. But we saw evidence of glazing. And he told you that wasn't from the fire. That was from the defendant running through his brakes. And he gave you everything. He told you parts tell their story. He didn't make all these assumptions in order to reach his opinion. Common sense tells you that it was the defendant that caused this. Now, I'm not asking you to hold the defendant accountable because he's a good person or a bad person. That's not what we're asking. I'm asking you to hold him accountable for his bad decisions. Those bad decisions that were so reckless that they were extreme indifference. Because those bad decisions, they took 4 members out of our community, injured and traumatized many others. Find him guilty of all the charges.
Thank you, counsel. Closing argument on behalf of defendant.
Judge, do you mind taking it down from the prosecution screen?
Good morning, ladies and gentlemen. I'm so glad the prosecution thinks they know what I'm going to tell you. They're incorrect. Let's put it that way. You know, as I was preparing for today, and I've actually been preparing what to tell you about this horrific and terrible collision, I've been thinking about this for a year. What am I going to tell you about what happened? Even as late as last night, I rewrote everything and said, you know, no, that isn't quite what I need to tell the members of this jury as to what happened. It isn't quite what I need to say. So I've decided that what I'm going to do is I'm going to, rather than read from my notes, I'm going to speak from the heart. I'm going to tell you what this evidence shows. I'm going to tell you what the evidence doesn't show. If it doesn't come across as polished as I would like, that's why. Over the last year, I've reread a book called To Kill a Mockingbird a couple of times. And if anybody's familiar with that book talks about fairness and equality in the justice system in the United States. It is, at least in my opinion, it's one of the greatest books ever written about the necessity for fairness and equality in the justice system. It was written in the 1930s in the Deep South, and so many of those qualities in that book that are addressed are applicable to today's society. Only in America does a man who speaks Spanish, is an immigrant from Cuba, can he expect to get a fair shake by a jury? This would never happen in another country. Only in America would this happen. But it's only going to happen if fairness enters the picture. It is only going to happen based on the jury. A jury is only good as the people on the jury, and the people are only as good as the fairness that they're willing to apply to the facts in the case. My job throughout this trial, and I hope I've been successful, has been to make sure that that fairness applies to my client. A courtroom is the only place a Spanish-speaking immigrant is going to get a fair shake. Every one of you promised that you would give my client a fair trial, and I have no reason to believe that you have not upheld your particular promise to us. So let's go ahead and talk about the evidence. Let's go ahead and talk about what the prosecution thinks I'm going to talk about. There are a few things in that book that stick out in my mind. The number one thing that sticks out in my mind about from To Kill a Mockingbird is the fact that, and I don't want to messed this up, so I will read this. People generally see what they look for, and they hear what they listen for. Now, what does that mean? That means that when you think he's a killer, every piece of evidence that you find is going to fit that narrative. They would have you believe that we have a killer sitting in this courtroom. They say he's a killer. He's not a killer. He's a flawed human being, yes. He's made mistakes in his life, absolutely. But he is not a killer. They tell you that he was acting with extreme indifference. If you look at this jury packet, you will not find a definition for extreme indifference. The reason you don't find a definition for extreme indifference is the law presumes that it's such a common term, it doesn't need a definition. Well, if it doesn't need a definition, why do they take everything he has done to try and convince you that he's acting with extreme indifference? Why do they need to try and build this up? Why do they need to convince you about something that frankly is negligence at best? Because if they don't, they know you won't even consider it. But extreme indifference, I would suggest to you, extreme indifference is something that is glaringly obvious, which the law says it's glaringly obvious. You don't need to sell that product. That product sells itself. The Boston Marathon bomber, that sold itself. That's extreme indifference. There's an agenda. You leave a bag along the marathon. You don't care if people get hurt. The Aurora Theater shooting, extreme indifference. You kill people inside the theater with a weapon. You don't care if people get hurt. Even road rage is extreme indifference. You get angry at somebody because they've cut you off, you chase them down, you cut them off, you may even actually hit them. That's road rage. That's very likely extreme indifference. They all have agendas. And you know what else they didn't have? They didn't have survivor's guilt. The defendant has survivor's guilt. You heard him. He wished he would have been the one that died in this particular accident, in this horrific collision. He's the one that wishes he was dead. Do you think the shooter from the Aurora shooting said, you know, I wish I was the one that was dead? No. Do you think the Boston City bomber thought he wished he was dead? No. People that commit road rage, you think they wish they were dead? No. What does that tell you about the defendant? What that tells you about the defendant is he was somebody that was completely overwhelmed by the circumstances. He is as traumatized as many of the people involved in the accident. Now, please don't take that wrong, because I hope that during the course of the past 3 weeks, I have treated everybody that was injured and affected by this accident with respect. If I haven't, if you don't believe I have, please don't take that out on my client. But I do not discount what this has put other people through. I do not discount what this has put the Palatano family through, the Ariano family through, the Bailey family, the Harrison family. I do not discount that. But you can also not discount the fact what this has done to the defendant. He was as much a victim of an accident in the fact that in the sense that it came upon him without warning, without any kind of indication what he could do, and he was overwhelmed by the circumstances. We know what was going on. If you can't hear me, I will yell, okay? Please tell me if you can't hear me. So, ladies and gentlemen, we know what was going on at the scene, okay? If he's running away, there's a deputy sheriff. There's a Jefferson County deputy sheriff. Why did he go seek out a deputy sheriff if he was trying to run away? Where was that guy, by the way? Where was the deputy sheriff that the defendant first talked to? Why didn't they call him? Because it doesn't fit their narrative. So, they said he was running away. Look at him. He's crying. He's wiping his eyes with his sleeve because he's upset. They say he's running away. He's being helped down the hill back towards the truck. This is not a killer trying to run away from an accident. This is a man who got overwhelmed by the circumstances and was trying to do the best he could to figure out what was going on. He actually sought out a police officer. Let's talk about the other people that the prosecution has put on the stand to try and make you convinced that Mr. Mederos is a killer. Let's talk about the Hulls. Now, the Hulls, think about what they said. Just think about what they said. They said they pull out from the intersection of the dirt road that intersects with the highway. They said that they saw him a quarter of a mile away. There are 1,760 yards in a mile. A quarter of a mile is 4 football fields. 4 football fields. They said they saw him from 4 football fields away. And yet he just came up on him so fast at 60 miles an hour. That is ludicrous. It's ludicrous to say that they saw him from 400 yards away and all of a sudden they were surprised he was there. The truth is they pulled out in front of him. The truth is that he avoided them. Says he doesn't remember it. Considering everything else that happened that day, is it really surprising that he doesn't remember everything throughout the day? I don't think that it necessarily makes him a killer. It does not make him a killer. His behavior was not that of a killer, because the Hulls were the ones that were responsible for him going into the other lane of traffic. Plus, don't forget, the Hulls decided they saw what they wanted to see and they heard what they wanted to hear. They saw the accident on the news and they decided, you know what? I'm going to help solve this crime. I'm going to call up the police and I'm going to say, God, guess what I just saw? They saw what they wanted to see and they heard what they wanted to hear. The same goes for the mechanic at the bottom of Berthoud Pass. I'm not saying these people are wrong. I'm saying they're mistaken. I'm not saying they're wrong. But he saw dust. He saw the accident and said, you know, here's what I think I saw. I want to help solve this case. So he calls up the police and they said, here's what I saw. So please keep that in mind when you think about the guy from bottom of Berthoud Pass. And we know that that's just not the case. Those brakes were not engaged. And we'll talk about Mr. Steele and the difference between Mr. Steele and Mr. Wink and Mr. Johnson here in a little bit. But there is definitely a controversy whether or not those brakes were even engaged at the bottom of Berthoud Pass. Now let's talk about Berthoud Pass real quick. You do not have to be a CDL driver to understand why there's a huge difference between these two passes, between Berthoud Pass and Genesee Pass. Keep in mind, this is Wyoming down here. Okay, I know this is a map is a little confusing, but Wyoming is in the bottom. So he's coming from Wyoming, and these switchbacks is what they're called. He's going uphill. You can't go fast because of the fact you have to slow down, make a U-turn, make another U-turn, get to the top of the pass, and then all of a sudden you're down again. You cannot generate the kind of speed that it takes to all of a sudden freewheel down Berthoud Pass. That's why this pass isn't nearly as dangerous as Genesee Pass, because there is not a flat line that allows you to, once you're at the top of the hill, it goes flat and then it goes down. This one is almost, think of it as almost a V. You go straight up the V and then you're down. That's why it's not a dangerous pass. That's why it's not as dangerous as Genesee Pass, because you can't generate the kind of speed that it takes in Genesee Pass. So, when Mr. Wink was asked the question, obviously Mr. Moritsky didn't like his answer. Here's why Mr. Wink is right. Just look at that map. That is not as dangerous a pass as the one that we're talking about where this horrific accident happened. So please keep that in mind when you're thinking about what Mr. Wink did. Now, this was where they looked at the trailer as it was pulled out from the fence. And again, I blew this picture up because I wanted you to see that as it was pulled out from the fence, there were no drag marks. So, the defendant told you that he tried to use the trailer emergency brakes, he didn't engage. Had the trailer emergency brakes engaged, you would have drugged, as this trailer was drug out from the dirt, you would have seen drag marks. Even Mr. Steele, he didn't admit what he said, but he did admit that he had an audible response when he saw that there were no drag marks in the dirt. He admitted that he said, oh, that's not good. So even he acknowledges that the trailer brakes had never engaged. But, of course, the prosecution still wants you to believe that he's a killer, so they saw what they wanted to see and they heard what they wanted to hear, and that was that, okay, well, we've got to explain why these trailer brakes didn't engage, so we are going to say that somehow he was responsible for making sure that these brakes weren't properly maintained. Well, I'm not saying that Tony is responsible for the trailer brakes because they never worked on the trailer brakes. No one worked on the trailer brakes. Miss Wilderman just said, well, he'll stand up and he'll blame Tony, Roque, and Andrade for these trailer brakes. No. No one ever worked on these trailer brakes. They passed inspection in February of 2019. How did they get so misadjusted? Why aren't Rafael Perez and Ms. Segura being held accountable for the fact they didn't maintain the brakes? Why aren't they being held accountable? They want you to hold the defendant accountable for his actions, okay? That's fair. That's why we're here. We're here for a fair trial to fairly hold him accountable for his actions. But why isn't Rafael Perez being held accountable for they didn't maintain the brakes? Please ask yourself that question, and I'll give you an answer. Because there sits the lowest hanging fruit. The lowest hanging fruit is the person that it's the easiest to go after. That's why he's being held accountable and no one else is being held accountable. Is that fair? Is that fair? You guys decide if that's fair. I'm here to suggest to you, I don't think that's fair. He's being forced to be held accountable, and that's fine. That's fine. He is willing to be held accountable for what he did. But hold him accountable for what he had control over. Don't hold him accountable for what he did not have control over. Let's talk about the statements that he made at the scene, okay? I believe that Ms. Wilderman said that the reason he said it is that he feels like he's guilty. Well, he did not commit an intentional act. No one is claiming that. In his mind, and it is supported by the evidence, this was a terrible, terrible, horrific accident. So when he's at the scene, he's not admitting guilt. He is saying, in my country, even if you get into an accident, you're going to jail. Well, guess what? And I don't think it's funny. I'm not trying to laugh at this. It's ironic. Even in this country, they made up their mind he was a killer Do you really think that when he went into the interview around midnight, they were going to let him walk out of that room without even knowing fully what had happened in a horrific crash like this? 4 people dead, other people injured. The street was shut down for days. They didn't have a full idea of what had happened, but did you really think they were going to let him walk out of that room? They had formed an opinion that he was a killer, and they aren't going to let a killer walk, even with, so he knew he was going to jail, because even in this country, when they make up their mind, they have the power, they have the authority to say, you're going to jail. So when he said that, that's not unrealistic, and that was a valid thought on his part, that I'm in trouble, I'm going to jail. But that was not an admission of guilt. They would have you believe it was an admission of guilt, but it wasn't. Let's talk about Mr. Hurley, the guy that talked about the logs. Mr. Hurley is what they call a true believer. He is somebody that sees what he wants to see and hears what he wants to hear. Everything to him is a logbook violation. And he couldn't explain why, of the 4 days that we're talking about, 2 of the days, there were no violations. There were no logbook violations. Castellano Trucking, they could have fined Castellano Trucking for logbook violations for their drivers on those 2 days, and guess what? That didn't happen. The 23rd of April and the 25th of April, the same day this happened. He said, well, I would have charged them. Well, the person that conducted the investigation had a difference of opinion. There were no charges, and there were no logbook violations on the 23rd and the 25th. But they saw what they wanted to see, and they heard what they wanted to hear. They wanted to try and twist this, manipulate this, somehow force a square peg into a round hole, and make you believe that because of these logbook violations, he's a killer. McDowell, the same way. He saw what he wanted to see, he heard what he wanted to hear, and they put these people up on the stand because they know extreme indifference in this case is not nearly as what term do I want to use? It's not as clear cut as they would have you believe. It's not as obvious as they would have you believe. So that's why they're trying to lay all these layers and say, well, if you believe this, you believe this, you believe this, you believe this, well, that amounts to extreme indifference. Or I'm telling you, extreme indifference doesn't need to be sold like that. Extreme indifference is a product that's obvious from the very beginning. You leave a bomb on the path of a marathon, road rage, shooting in anything. They have an agenda. Now, they say his agenda was he wanted to get gas and he wanted to take a shower. He didn't have to drive fast. He didn't have to be in San Antonio till 2 days later. A full 48 hours. San Antonio is 1,800 miles. It's not across the country. It's not that far. You can easily make San Antonio and stay within the Department of Transportation regulations with sleep, and you heard him discuss how many hours a day you can work or drive. It's 28 hours he had available to him to get to San Antonio. Divide 18 by 28 hours, and that'll tell you how fast he had to go over the course of the next 2 days to make it to San Antonio. So speed and his need to get home was not an agenda. So what other agenda would he have had? There isn't one. There isn't one. There's no agenda. He took Highway 40, and here's the defendant's biggest mistake. He trusted Raphael. He's a young kid. He's got a job. Really, his first real job as a truck driver. And he trusts his boss. He's got a guy that's been driving trucks for 10 years. Raphael said, this trailer's okay. Take the trailer. It's cool. He asked him, you sure the trailer's okay? Yes. Yes, the trailer's okay. When Raphael said, don't take Highway 287, don't take I-25, the defendant said, okay, he's my boss. Okay. That was his biggest mistake, is that he trusted him. He shouldn't have trusted him. He should have been a little bit cynical, but he wasn't. Is he the first 23-year-old, and he was 23 at the time, is he the first 23-year-old to trust their boss blindly? I would suggest to you that he's not. He is not the first person to trust his boss blindly. He's not the first person to take their word and not question it. So when Raphael said, don't take Highway 287, don't take I-25, even though Mr. Mederos knew in his mind that he wasn't as experienced in the mountains as he would like to have been, he said, well, I'll trust Raphael's word. And he took Highway 40. Shouldn't have done that. He didn't have enough experience. But he took Raphael's word. And if you remember, at the beginning of this trial, I said, experience is not something that's created, it has to be endured. You can't create experience, you have to endure it. Well, you don't know what you don't know until it comes time to know it. He thought he was fine. He'd been in mountains with his brothers. It's not the same thing. When you are actually enduring something and something goes wrong, that's when you don't know what you need to know. You don't know what you need to know when you need to know it. That's when things go wrong. Experience isn't important when things are going smooth. Think about any other thing you do in your life. Parenting, for example. Everything's smooth as long as the family's getting along. But when all things get chaotic and you got to try and sort things out, that's when experience comes into play, because you know how to calm things down. Think of your own respective jobs. As long as everything's going fine, experience doesn't really matter. Experience only matters when things go bad. And that's what it is in this case. Experience, it went bad, and he had no idea how to fix it. He had not been trained how to lay it down on its side. Nobody knows how to lay a truck down on its side. You heard from all kinds of CDL drivers. And so I asked him, I said, tell me how to do that. Tell me how to lay this thing down in the middle of the road and avoid hurting other people. Tell me how to do it. Not one person could tell me how to do it. Not one. But they all said, if it was me, this is what I would have done. I said, well, then please tell me how you would have done this. What would have prevented other people from being hurt if you had laid it down in the middle of the road as they suggest? Where would the trailer have gone? The trailer would have continued forward. The trailer may have went into the other lane of traffic. The truth of the matter is that by the time this truck got to the hill, the bottom of the hill, there were no options available. All the options were not available, in which no one was going to get hurt. This was a terrible, terrific, and catastrophic accident, but that's exactly what this was an accident. He did everything that he knew how to stop this vehicle, and everything failed. And contrary to what the prosecution has said, he didn't purposely avoid the on-ramp or the runaway truck ramp. He was moving in and out of traffic. Remember, he said he was like a serpent. He was moving in and out of traffic. Why would he do that if he didn't care about hurting other people? Why was he avoiding other cars? If he is the killer they say he is, why would he care? He was doing what he knew how to do in order to avoid hitting somebody. So he's weaving in and out of traffic. Why would he put his flashers on? We know he had his flashers on. You can look at the video. If he wasn't trying to somehow avoid other traffic, why would he put his flashers on? Pedro Oliveira said, yeah, okay, I see his flashers. We know he had his flashers on. If he wasn't trying to avoid other traffic, we saw from the CSP officers. Everybody remember that video? I know it's been 3 weeks, but there is a video from the CSP officer that shows him going down the side of the road. Why would he take the side of the road? Why wouldn't he have just crashed into the cars long past the CSP officer? Why did he wait until he got to the bridge? He told you that he considered going into the bridge, but was concerned that there'd be an explosion. Why would he care? Why would he care? If he truly didn't care about other people getting hurt, why would he care whether there was an explosion? Now, all of these truck drivers that came out and testified have testified that, here's what I would have done. Well, that's what they say. It's easy to be an armchair quarterback. It's very easy to say, this is what I would have done. But the fact that Mr. Mederos was not willing to commit suicide doesn't make him a killer. Because it would have been suicide. You heard one of the truck drivers say that if he would have laid this down on his side, that's suicide. Would he have been, would people have said that he was a hero if he would have laid it down on its side? No. People still would have been hurt. So he made the decision. He wasn't prepared to have to make that decision whether or not to commit suicide. I would suggest to you that when he started at the top of the hill, he had no idea that by the time he got to the bottom of the hill, he had to make a decision whether or not to commit suicide and lay this truck over, or make a decision about suicide and run this into a bridge. If you are going to be somebody that has to decide, am I willing to give up my life for my country and the military? Am I willing to do something else that's willing to cause me to lose my life? You generally have to have some time to think about it and see if you really have that ability to do it. Now, they would have you believe that his inability to make a decision about committing suicide would make him a killer. I would suggest that's not fair, that's not accurate, and that isn't the human experience. Let's talk about Mr. Steele real quick. Now, Mr. Steele still doesn't have an explanation as to why if this truck was in 8th gear, like he said, he still doesn't have an explanation as to why the Jake brake wasn't being employed, or why there's no damage to the engine. We still don't have an explanation, if we want to believe Mr. Steele, we still don't have an explanation as to when this thing got into 8th gear. When? All the evidence indicates that it was in 6th gear at the top of the hill. So, if Mr. Steele's correct, when did it go into 8th gear? No one ever explained that. Because it can't be explained, because it isn't true. And the reason we know it isn't true isn't because of Mr. Wink, it isn't because of Mr. Johnson, it's because of Mr. McCutcheon, the Burger Planet guy. That's how we know Mr. Steele's wrong. Because when you listen to the video comes by, there is not one sound from that truck other than the wind that you hear from a truck that is going down the road. Not one sound, not one sound. The engine's not stressed. And even Mr. Steele admits, well, yeah, if it was going 78 to 85 miles an hour, which if you remember, I think it was Officer Steiner from Arvada said, I think it was going 78 miles an hour at the time of the collision. The person that did the traffic report said he estimated it at 85. 78 to 85 is what the estimated speed was at the time. But if it was going that fast, there should have been extensive engine damage. But he can't explain why there isn't. Because he has to admit that it far exceeded the governor of 2,100 RPMs. It exceeded that RPMs by going up 3,300 to 3,600 miles an hour. Or not miles an hour, RPMs, I'm sorry. Can't explain why there's no damage. You don't have to do anything other than to listen to that Burger Planet video. And Mr. Wink is not somebody that is so locked into an opinion that he won't change his opinion based on facts. Well, Mr. Steele is. Mr. Steele can't change his opinion, because if he changes his opinion based on the evidence, they don't have a case anymore that my client is a killer. He can't change his opinion, because then they have to admit that this was an accident. They have to admit that this truck was in neutral going down the hill. They have to admit that my client was trying to get this into a lower gear, but because his trailer brakes had failed and his service emergency brake had failed and his trailer emergency brake had failed, that's why he couldn't get it into gear. That's why he couldn't use the Jake brake. They would have to admit that that's what happened, is that this was a terrific accident. Now, remember when we first started in voir dire, I talked to you about the fact that our legal system cannot be result-oriented. And everybody seemed to agree that we cannot have a result-oriented criminal justice system. Well, she said these are the results. I don't disagree with her. I don't disagree with her about that these are the results. But they have to prove what's going on up here, because it isn't just the result that makes a crime. It's something called the mens rea, or what was going on in the defendant's mind at the time of the crime. That's what you guys have to decide. That's what you have to do to fairly analyze the evidence and figure out if we're talking about extreme indifference or if we are talking about something else. Reckless means that you have to consciously disregard the safety of others. Reckless is actually defined two separate ways in the instructions. When you look at reckless driving, which is instruction number 14, I don't know if you all have your instructions in front of you or not. If you would, just turn to instruction number 14. Okay, so reckless driving, which is one of the counts, indicates that you have to drive in a wanton and willful manner such that it was performed heedlessly without regard to the consequences of the right or safety of another person's or property. So in other words, you have to know what you're doing is dangerous to someone else and that you purposely put yourself in that situation. A road rage, somebody that is speeding 120 miles an hour in a 60 mile an hour zone. You have purposely put yourself in a position that puts other people's property or safety at risk. That isn't what happened here. Did he put himself in the truck on Genesee Hill? Yes. Did he purposely drive Genesee Hill knowing that his brakes were out? There's no evidence that establishes that. And even if they argue there is evidence, you can also have to look at it and say, okay, maybe something happened, maybe he should have known, but you know what? They have the burden to prove it beyond a reasonable doubt. And what exactly does a reasonable doubt mean? Reasonable doubt means you have to be able to look at this and you have to be able to say, that's what happened. I don't have any hesitation at all. That is what happened. You can't do that in this case because the evidence doesn't support it. Let's look at the vehicular assault counts and the vehicular homicide counts. Now vehicular homicide is instruction 12. If you want to look at instruction 12, instruction 12 talks about driving in a reckless manner. You actually act recklessly is what it says. He has to consciously disregard a substantial and unjustified risk that a result will occur. So in other words, he has to think, okay, I know I'm driving without brakes on Genesee Hill. I don't care. I don't care if people get hurt as a result. Don't care. That isn't what happened. What happened here is he thought he had brakes. He looked at his brakes. He called his brother. He called Raphael. He crawled under the car with Raphael and his brother, or not under the car, I'm sorry, under the trailer, under the truck, and said, my brakes, do you think they're okay? He was being conscientious. He was doing actually what he should have done, which is taking precautions to make sure that somebody with more experience told him he was okay. Why did he do that? Well, this is the first time he had driven in the mountains. He'd been up and down a mountain pass and wanted to make sure that he wasn't missing something. I'm not saying you should commend him for doing that, but you should also recognize that he was actually doing the right thing. What he probably maybe should have done, taken a picture of the brakes, sent them to Raphael and said, what do you think? I mean, in modern technology, he could have done that. But he was also, don't forget, in a mountain pass where calls, Raphael told you he called him from the side of the road. So Simpson said, well, that phone call wasn't there. Well, Raphael said it was. Raphael said he got a phone call from him about after he'd come down off of Berthoud Pass. He got more than one phone call, and he admits that he called from the bottom of Berthoud Pass. So yes, Mr. Detective Simpson said, well, that phone call wasn't recorded. Well, according to Raphael, it was. So he did what he was supposed to do. He didn't see smoke, so he thought he was okay. Now, I think the prosecution said, well, he should have waited for roughly an hour. Well, you heard a couple of other drivers. I think Mr. Rowe said, I was only going to wait for a few minutes when my brakes were hot. When I was parked under the trailer, I only thought that I needed to wait 10 or 12 minutes. So I don't know that that's necessarily accurate. When he said he didn't feel that the brakes were hot, so he gets in the truck and then he goes down I-70. As he's going down the hill, of course, I would like you to consider the fact that maybe there was some tunnel vision going on here. If anybody's ever been placed under stress, especially unexpected stress, just think about that for a second. You focus on one thing, and that's why they call it tunnel vision, is you are looking at something right in front of you. Maybe you peek to the left, maybe you peek to the right. But to expect him to know exactly where all the signs were and where I lost my brakes, I think that's a bit unfair to expect that kind of mental acuity out of a 23-year-old man. So when he goes past the on-ramp, what did he say? I'm looking for the one that goes up into the mountain. To me, that's what an on-ramp is. Well, that isn't what this one was. As you look at the pictures, look at the video, it isn't that obvious where this on-ramp is. And if this is the first time you've ever driven it under a period of unexpected stress, it's unfair to say, well, you purposely avoided that on-ramp or that runaway ramp. That isn't what happened. This was somebody, like I said, and I stick by this, he was drinking out of a fire hose. Everything was happening to him so fast. He was trying to make decisions right like that. And each decision didn't give him reason to think that it was going to stop. So when he gets to the bottom of the hill, after he tried to make all these decisions, everything's going through his mind. He really was out of options. He was out of options. And people unfortunately were injured. People unfortunately died as a result of this, but that doesn't make him a killer. That doesn't make him a killer. Let's talk about the interview for a little bit. Now, let's be blunt about something. Mr. Mederos is what they call a concrete thinker. You have two kinds of thinkers, two kinds of people that you deal with in life. One's a concrete thinker, one's an abstract thinker. Abstract thinkers don't anticipate what the next question is going to be, or don't anticipate, well, let's fill in the blanks. So when someone says, well, have you driven I-70 before? A concrete thinker will say, well, yeah, I've driven I-70 before. I've gone down Kansas. I've gone into Ohio. I think I-70 goes into Ohio. I might be wrong about that, but okay. Well, I know it goes to Kansas, so let's stick with Kansas. So yeah, I've driven I-70 in Kansas before. Doesn't think about filling in the blank and say, but I've never driven I-70 in the mountains before. But they would tell you that that is someone that's being deceptive, someone that's not telling the truth. Well, you heard him talk up here on the stand. He'll answer a question if you ask him a specific question, or he'll give you a specific answer to a specific question. But he doesn't think the way that they give him credit for. They give him the credit for a lot more sophistication than he has. He is very concrete in his thinking, and they think he's out there thinking of that he has thought of consequences, thought of people being hurt, and just consciously disregarded them. That is not the sophistication level Mr. Mederos has. He doesn't think as far ahead as they give him credit for. He thinks in the moment and only in the moment. Now you could say, well, that's exactly why we're concerned, and I understand that concern. But what that also means is that what he was doing is in his concrete mind, this is what I've been trained to do. Raphael has told me this is okay. It looks okay. I'm moving forward. He stays right in the moment. But being a concrete thinker doesn't make him a killer. That doesn't mean he's a killer. That means that he thinks not unlike a lot of people in this world that are concrete thinkers. Not everybody's an abstract thinker. It's not a mental illness. It's simply a fact of life. So as you're thinking about this interview, you saw how confusing it was. We have very competent interpreters here, and they struggled. Wait till you see the video if you think there was a struggle. There were 3 people talking at one time to Mr. Mederos. He's trying to figure out, one guy speaking in English, one guy speaking in Spanish. They're trying to figure out what they're trying to ask him. And then you add to the fact that he is somebody that thinks in the moment, doesn't fill in the abstract thoughts, and all of a sudden everybody says, well, he's not telling the truth. You go ahead and look at that video. You'll see that video doesn't make him a killer. That video doesn't make him deceptive. That video doesn't make him a liar. That video is somebody that is frankly in shock from this accident. Now, no one can argue that Mr. Mederos isn't still affected by this accident at the time of the interview. If it was something that was a conscious decision on his part, why would he be so affected by it? Because this was something that happened to him without notice, without warning, and without conscious thought on his part. That's why he's affected by this. That's why you'll see he's kind of got a deer in the headlights kind of look. He's got this 1,000-yard stare. He's still under the effect of this collision. So take a look at that statement. Excuse me. Let's talk about proximate cause, if we could. Proximate cause is in that instruction number 13 and 12, which is the vehicular homicide and vehicular assault. Proximate cause means that, and you can go ahead and look at that on 13. That's the best definition on the instruction number 13. It means an act or failure to act which is a natural and probable consequence produced by the claimed injury, the cause of which the claimed injury would not have occurred. So the reason that's important for proximate cause is that there were issues with those trailer brakes. There were issues with those trailer brakes before it left Houston. Raphael said, those trailer brakes are fine. Go ahead, take them. It's fine. Mr. Mederos had never touched that trailer before. And again, he should not have just taken Raphael's word for it. He should have just simply said, wait a minute, I need to check it. But he didn't do that. He didn't look at Raphael's statement cynically. He took his word. That was a mistake. That was a mistake. He shouldn't have taken Raphael's word where to go on the mountain pass. That was a mistake. But proximate cause, when we're talking about proximate cause, I would suggest to you, and this is supported by Mr. Johnson and Mr. Wink, that Had those trailer brakes been operable, and had they been functioning, and had they been properly maintained before that trailer left Houston, this accident never would have happened. So the fact is that trailer brake was going to contribute to this accident, but Mr. Mederos had no idea that what he was dragging behind him from Houston was an inoperable trailer. He had no idea that when he needed those trailer brakes, they weren't going to exist. He didn't go over any mountain passes from Houston through Oklahoma to Kansas to Fort Collins. He didn't have to really rely on those trailer brakes until he got to Genesee Hill. You heard him, and you heard everybody say that the best way to go up Berthoud Pass is to use a Jake brake. The best way to go down Berthoud Pass is to use a Jake brake. And Mr. Mederos said, yeah, I used a Jake brake up, but I used a Jake brake down. We know the Jake brake was operable, so we know that he is telling the truth that the Jake brake was working. He didn't need or wouldn't expect that the trailer brakes were going to assist in stopping the car or the truck going up Berthoud Pass or going down. But when he needed them, he didn't know that they weren't going to help him. So he was just as shocked as anybody when that trailer emergency brake didn't apply. So what proximate cause and how that comes into play with vehicular assault and vehicular homicide is that if there is another cause as to this collision, and it isn't due to the behavior of the defendant, the defendant's behavior is not the proximate cause of this crime. So not only do they have to prove what's going on in his head, but with vehicular assault and with vehicular homicide, they have to prove proximate causation. They also have to prove proximate causation for the careless driving count as well.
You're at 50 minutes, Counsel.
I have 50 minutes left, or I'm at 50 minutes.
You're at 50 minutes.
I thought so. I thought, geez, I lost track of time there. Okay, thank you very much, Your Honor. The final thing I want to say is that the one thing that is not subject to majority rule is your conscience. Your 12 individual consciences. If you vote with your conscience, and if you vote based on the evidence, you'll see that my client is not a killer. He's a flawed human being, but he's not a killer. They want you to believe he is. And I know I can say this much. Mr. Maritzky's going to get up here and tell you that he is a killer. I know I'm right about that. But he's not. The evidence doesn't support it. People that are as disregarding of human life as much as they claim Mr. Mederos is, don't have survivor's guilt. They aren't sorry that they survived the collision. They aren't sorry they survived the accident. They realize that they didn't mean to do it, and yet it's had a profound effect on a number of people's lives. He wishes he could change it. He can't, unfortunately. But he is not a killer. If you vote with your conscience, you'll see, and your verdict will reflect, that this was a horrific accident, but he didn't commit a homicide, and he didn't kill anyone. They're dead as a result of a terrible accident, yes, but he did not kill anyone. And I think you need to make sure that you draw that distinction in your verdict. Ladies and gentlemen, it's been kind of a long 3 weeks, I understand that. But I truly appreciate the effort that you've put into this case. And with that, Your Honor, I'll sit down.
Thank you, Counsel. Rebuttal on behalf of the people. You have 13 minutes, Counsel.
Oh, I appreciate it, Your Honor. May we have the screen as well? Thank you so much. Ladies and gentlemen, I don't have a lot of time, but I have a lot to say. And I'm sure some of you are sitting there saying, well, it's good you don't have a lot of time because you talk a lot. I want to start with the very obvious thing. When Mr. Colgan just said he's going to stand up and call the defendant a killer, not one time during this trial did we ever call him a killer. In fact, we told you at the beginning, what we expected of you is that you follow the rules. So you have to ask yourselves why he said we would call him a killer. It's because he wants you to use sympathy or prejudice in your decision. That's not what we're asking you to do. We're asking you to follow the facts. The facts are that this defendant put himself in a position where he shouldn't have been. And it was from the very beginning. If we were talking about this in another context, if a resident in a hospital had walked into a surgery room and told the people, I have experience, go ahead and rely on it, and I'm going to do surgery on that patient, and then he killed that patient, no one would be thinking twice that this was extreme indifference. That's what he did. He put himself there. Everybody else relied on what he said. So when he stands up and says he relied on everybody else, what do we have? Blame. Every single step along this situation, he says, is somebody else's fault. It's not. Mr. Colgan also used the words and the thought process of, hey, what's the agenda? It's like putting a bomb somewhere and leaving it there to marathon. Why did he do that? Because he wants to tie it to the word killer. We didn't call him a killer. We didn't say that he left a bomb. He was driving a bomb. He pulled the pin on a grenade and threw it into a group of people, and he was with that group of people, but he put himself there. But why does counsel want that to be the narrative? Well, that's because he wants you to believe that we're saying he's a murderer. He's not. You have to have intent. That's why he uses words like purposefully put himself there. That's not what recklessly says. Recklessly says you know of some potential risk and you say, you know what? My cost-benefit analysis means that I am going to choose my choices over other people's safety. That's what he did. He decided that he wanted to drive that vehicle in a poor manner. But let's talk about the holes. They want to blame the holes. Okay, we're going to blame the holes again when he's driving poor. How would the holes have known that he had a Texas plate and the Saratoga logo on it? And they called in because they felt it was appropriate enough to let everybody know how he was driving, but they pulled out in front of him. Okay, so we put blame on somebody else again. What does that mean, really? They were pulling out from a stop, expecting the person who's coming down the road to be going the speed limit, which was 45. And at that point, he's doing over the speed limit coming fast. They're still getting up to speed around the corner because they're doing the travel. That distance that gets closed, of course, there's a problem that he has because he's speeding down that road going too fast and runs them off the road. But again, we have the problem of where is the blame put? It's on them. Let me talk about Raphael. Raphael is the one who makes the decision. It's not the case. Sixth gear coming over the hill, ladies and gentlemen. That's what we told you in opening. That what the problem was is he had chosen the wrong gear. He was in a high gear coming over the hill. Now, it's interesting, and I want you to pay attention to what the expert said, because Mr. Steele told you, you know what I do? I just wanted to see what the parts told me. Those parts would tell me something. He said, I found it in 8th gear. Okay. Then we asked him, do you know what gear it was in going on the hill? Nope. Okay, so that's what he told you. Why did he want to follow that up? Because their experts in the first instance said what? Oh, you know what? This is overspeed, and there's engine damage, and it was mechanical failure that makes him not guilty. Well, that wasn't the case. We in opening told you it was his choices, and that choice of 6th gear coming over that hill was the choice that put him there. Too fast. Ask yourself why he was going first and second on Berthoud Pass using his Jake brake. Did the Jake brake mysteriously not work for Genesee? Well, he says he turned it on. Well, he was only going 35. He didn't need to shift, but he made a decision. Counsel talks to you about concrete thinkers, people who follow rules step by step. You'll have this. You can go back there and look and see what step by step options he had, what he was told, what he knew. A CDL is a special license that he had to study for and that he knew. But when it comes time to say, hey, you did something wrong that you knew was wrong, I relied on somebody else. That was their problem. Recklessly is not purposefully. Please look at the instructions, follow the instructions. Counsel tells you, and repeatedly says things like, oh, when Mr. Rowe was parked under the bridge, look at the Faro scan. That's why the Faro scan was done. There's so many points in that, it's past the line on the bridge. Well, then defendant says it explains, oh, you know what? I must have hit him, and when I hit him, I was trying to take speed off. He was not hit by them. You'll see the cars that hit him. He pushed cars from the side into that, but that was a vehicle that was parked with its emergency brakes on, stopped, past the bridge. You can see where the damage is. You can assess that. The path that he took was directly into people that he knew were smaller vehicles. He took out the people that he knew he was taller than, weighed more than, that would slow him down and give him an opportunity to live. I want you to watch Trooper Renfrey's video as well. Trooper Renfrey's video shows you, I can have the screen. This is what Jared Steele, I'm going to jump around a little. This is what Jared Steele told you. I want you to look at that. Look at those trailer wheels. Directly above each of those wheels is the burn spots where those wheels would have been heated up. I want you to look at the burn marks in the lumber. Directly next to those wheels is where those are burned, where a heat source was. And you'll have the photos that you can look at the tires and see where the burn marks are on the tires. So when their experts tell you those brakes weren't functioning, they were functioning until he pulled the emergency brake. Remember in the interview, he said the emergency brake happens at around C470, around 6th Avenue, around 6th Avenue. Well, that's important because that's down the hill, and that tells you he was trying to baby this down the hill until he saw the traffic. And when he saw the traffic, panic sets in. And panic sets in and he starts pulling everything he can, and then you watch the Empire Nissan video, and you see smoke coming out of that thing, and it's burning up. The smoke's flying up. Now, there is dust and debris, too, and you have to be fair. But imagine if we didn't provide both sides of all of this. So you might have been asking yourself, well, why are you putting it in? Why are you putting in evidence that says it's in gear here, but you're telling us someplace else it's this? Because we don't get to decide what the facts are. We have to present you the facts, which is what we did. I want to tell you what the agenda was. First thing, the defendant says, I wish it was me. You get to assess credibility and what he was like on the stand. I want you to watch the video and see if the video of the defendant's interview was the same type of conversation that he had on cross-examination. When it was direct examination, he knew everything to a T, where it was, and what was going to happen. And you get to determine whether what he said makes sense and whether he was actually trying to answer the questions that were asked of him, or whether it was something other than that. When he was faced with the decision of, oh my goodness, you know what I didn't do? I should have never shifted out of 6th gear because the manual says you're supposed to be in the gear, and that he knew his brakes had to be gone at that point. That's the most crucial thing here. He knew his brakes were gone before he was out of gear. So really what was happening, I would submit to you, is he came over that hill in an even higher gear, probably 9th if you look at that, because he was going fast, coming down the other hill, coming up over the hill to get speed. He was probably in 9th. He shifted out of gears because he figured, oh, I've got a big hill now and I'm on the downhill side, I better get into his lower gear. And then he got stuck. And that's what every expert said. You gear lock, locks you out of the gear. That's why that decision is so bad. And that's why that manual in 5 different spots tells you exactly that. And for the defendant to stand and say, well, hill, mountain, I think hill is different. Going down any hill is the same. It's the length and grade of the hill. So for the defendant to say, I didn't understand, well, he has to know that there are hills in all of the places that he said he had driven to, and that those hills are substantial enough that he would have had to use the Jake brake, or that he would have had to use service brakes and everything else appropriately. So I'm inexperienced when it is convenient for me, is what we have. He says, I wish it was me. You get to determine whether he believes that. He took the path that hit the semi. And I'm not going to play this because it's going to eat into my time, but I want you to watch that. When Trooper Renfrey gets up to the very top of that, you'll see where the defendant actually goes into the line of traffic. He hit another car. He hit Miss Ross's car, the car behind it, and pushed Miss Ross into it. It's way before the bridge. And that's when he made the decision, because he could see the semi under the bridge that he actually pushed cars into on his left side, Mr. Chacombs, and he could see the semi that was parked past the bridge, Mr. Rose. He took the path directly between him because his thought process was the following. And the evidence will show you if you look at the diagrams and everything else. That semi will kill me if I hit it. That semi will kill me if I hit it. There's small cars in the middle of this. I'm going to go right through those. I'm not going to tell you how to, I don't want sympathy to play any part of this. I want you to follow the facts. That's the decision that he made. And you get to look at the decisions he makes through the lens of that final decision. Now, it's important to know, I tell my kid all the time, it's important, what you do when nobody is watching is an issue. Who the defendant told you he was at that scene. Defense counsel stood up and gave you that. That's who he told you he was. You heard Miss Robertson tell you, I told him he had to stay. And I told those other people to make sure he stayed here because he was trying to leave. Well, when the police get there, this is what you get. When the authorities are there, after he said, I'm going to jail, that is who he was with Miss Robertson.
You have 1 minute, counsel.
His agenda, his work, a belief that he is special and somehow rules don't apply to him does not mean that he doesn't know something. It means he thinks he's special and that he's above the law. And I'm sorry I've used up all my time, but this trial is also about giving a fair trial to these people. And these people. And these people. And his family. He's guilty. Please find him such. Thank you.
Thank you, counsel. We'll return to the jury instructions and specifically instruction number 20. Members of the jury, you may discuss this case only when you are all present, and you may only deliberate in the jury room. No juror should attempt to discuss this case with other jurors or anyone else at any other time except when all the jurors are in the jury room. Instruction number 21. Once you begin your deliberations, if you have a question, your foreperson should write it on a piece of paper, sign it, and give it to the bailiff, who will bring it to me. The court will then determine the appropriate way to answer the question. However, there may be some questions that under the law the court is not permitted to answer. Please do not speculate about what the answer to your question might have been or why the court is not able to answer a particular question. Finally, please be sure to keep the original question and response. Do not destroy them, as they are part of the official record in this case and must be returned to me when you return the instructions and verdict forms at the end of the case. Instruction number 22. The bailiff will now escort you to the jury room, where you will select one of your members to be your foreperson. Your foreperson will preside over your deliberations, and shall sign any verdict form that you may agree on according to the rules that I'm about to explain. The verdict for each charge must represent the considered judgment of each juror, and it must be unanimous. In other words, all of you must agree to all parts of it. This requirement also applies to any determinations that you make in response to verdict questions which you conclude should be answered. Only one verdict shall be returned signed for each count. The verdict forms, verdict question forms, and these instructions shall remain in the possession of your foreperson until I ask for them in open court. Upon reaching a verdict, and if required by your verdicts, answering any verdict questions, you will inform the bailiff, who in turn will notify me, and you will remain in the jury room until I call you into the courtroom. You will be provided with 42 verdict forms. Of those verdict forms, 35 contain verdict questions with directions that explain under what circumstances you're to answer the questions. When you've unanimously agreed upon your verdicts, you will select the option on each form which reflects your verdict, and the foreperson will sign the verdict forms as I have stated. Similarly, if you conclude that any verdict questions should be answered, you will select the option on each verdict question form which reflects your unanimous decision, and the foreperson will sign each verdict question as I have stated. I will now read to you the verdict and verdict question forms. You must not draw any inferences based on the order in which I read them. The verdict and verdict question forms you will receive read as follows. They indicated you do not have the verdict forms. I have the verdict forms that will go into the jury room with you. Each verdict form has the case caption, People of the State of Colorado versus Rogel Aguilera-Mederos. Jury verdict for count 1, charge of assault in the first degree as to William D. Bailey. Roman numeral 1, we the jury find the defendant, Rogel Aguilera-Mederos, not guilty of assault in the first degree as to William Bailey, the place for the foreperson to sign. Roman numeral 2, we the jury find the defendant, Rogel Aguilera-Mederos, guilty of assault in the first degree as to William D. Bailey, a place for the foreperson to sign. The second page of this verdict form reads, we further find, with respect to the verdict questions for this count, as follows. 1, did the defendant cause serious bodily injury or death? Answer yes or no, with a box for yes, a box for no. 2, did the defendant use a deadly weapon? Answer yes or no, with a box for yes and a box for no, a place for the foreperson to sign. There are instructions at the bottom of the verdict form indicated by an asterisk that reads, the foreperson may sign only one of the above, 1 or 2. If the verdict is not guilty, then 1 above should be signed. If the verdict is guilty, then 2 above should be signed. Further instruction, the foreperson should use ink to sign on one of the 2 lines indicating a verdict of not guilty or guilty. If the verdict is guilty, the foreperson should use ink to mark the appropriate spaces indicating the answers to each verdict question, and then sign on the line following each verdict question. That is form for count 1. Count 2 is for Mr. Harrison, the same charge, the same verdict form. Count 3 is for Mr. Lamas Ariano, same form, same questions. Count 4 for Mr. Politano, same form, same questions. Count 5 for Ms. LaGuardia. This is the same form, the same questions. Count 6 for Ms. Ross, same form, same questions. Then we come to jury verdict form, count 7, charge of criminal attempt to commit assault in the first degree as to Paul Gregory. It reads as follows. We, the jury, find the defendant, Rogel Aguilera-Mederos, not guilty of criminal attempt to commit assault in the first degree as to Paul A. Gregory, a place for the foreperson to sign. Roman numeral 2, we, the jury, find the defendant, Rogel Aguilera-Mederos, guilty of criminal attempt to commit assault in the first degree as to Paul Gregory, a place for the foreperson to sign. The second page of this verdict form reads, we further find with respect to the verdict question for this count as follows. 1, did the defendant use a deadly weapon? Answer, yes or no, with boxes yes or no to be marked, and a place for the foreperson to sign. Similar instructions at the bottom. The foreperson may sign only one of the above, Roman numeral 1, Roman numeral 2. If the verdict is not guilty, then 1 above should be signed. If the verdict is guilty, then 2 above should be signed. Further instruction. The foreperson should use ink to sign on one of the 2 lines indicating a verdict of not guilty or guilty. If the verdict is guilty, the foreperson should use ink to mark the appropriate spaces indicating the answers to each verdict question, and then sign on the line following each verdict question. That is to count 7. There are then similar forms for count 8 through count 31, each for charge of criminal attempt to commit assault in the first degree, and then it lists each verdict form, the separate alleged victim for the criminal attempt charges. Identical verdict forms, except as to which alleged victim is listed for each attempted charge. We then go to jury verdict, count 32, charge of vehicular homicide as to William Bailey. And this reads as follows. We, the jury, find the defendant, Rogel Aguilera-Mederos, not guilty of vehicular homicide as to William Bailey, a place for the foreperson to sign. Roman numeral 2. We, the jury, find the defendant, Rogel Aguilera-Mederos, guilty of vehicular homicide as to William D. Bailey, a place for the foreperson to sign. Either one of those is to be signed depending on your verdict. There are 3 more vehicular homicide verdict forms, 1 with respect to Mr. Harrison, 1 with respect to Mr. Lamas, and 1 with respect to Mr. Politano, in addition to the one I just read you for Mr. Bailey. Each is the same except for a different person. We then go to count 36, charge of vehicular assault. This is as to Alexandra C. LaGuardia. Roman numeral 1. We, the jury, find the defendant, Rogel Aguilera-Mederos, not guilty of vehicular assault as to Alexandra C. LaGuardia, a place for the foreperson to sign. Roman numeral 2. We, the jury, find the defendant, Rogel Aguilera-Mederos, guilty of vehicular assault as to Alexandra LaGuardia, a place for the foreperson to sign. Again, it indicates the foreperson may sign only one of the above, 1 or 2. If the verdict is not guilty, then 1 above should be signed. If the verdict is guilty, then 2 above should be signed. There are 2 such verdict forms for the charge of vehicular assault, 1 for Ms. LaGuardia, 1 for Ms. Ross. They are identical otherwise. There is a single verdict form for count 38, charge of reckless driving. Roman numeral 1, we, the jury, find the defendant, Rogel Aguilera-Mederos, not guilty of reckless driving, a place for the foreperson to sign. Roman numeral 2, we, the jury, find the defendant, Rogel Aguilera-Mederos, guilty of reckless driving, a place for the foreperson to sign. Again, it states the foreperson may sign only one of the above, 1 or 2. If the verdict is not guilty, then 1 above should be signed. If the verdict is guilty, then 2 above should be signed. And finally, there are verdict forms for the charge of careless driving. First one, this is for count 39, charge of careless driving as to William D. Bailey. Roman numeral 1, we, the jury, find the defendant, Rogel Aguilera-Mederos, Aguilera-Mederos not guilty of careless driving as to William D. Bailey, a place for the foreperson to sign. We, the jury, find the defendant, Rogel Aguilera-Mederos, guilty of careless driving as to William D. Bailey, a place for the foreperson to sign. The second page of this verdict form contains the following question. We further find, with respect to the verdict question for this count, as follows. For defendant's actions, the proximate cause of the death of another, answer yes or no, with boxes for yes, a box for no, a place for the foreperson to sign. The instructions are as follows. The foreperson may sign only one of the above, one or two. If the verdict is not guilty, then one above should be signed. If the verdict is guilty, then two above should be signed. Further instruction, the foreperson should use ink to sign on one of the two lines indicating a verdict of not guilty or guilty. If the verdict is guilty, the foreperson should use ink to mark the appropriate spaces indicating the answers to each verdict question and then sign on the line following each verdict question. There are 4 forms. They're identical except they identify a different person. Mr. Bailey, Mr. Harrison, Mr. Lamas, and finally, Mr. Politano. That constitutes the 42 verdict forms that you will have. I'm going to clip verdict forms. The originals will go back to you, as will the instructions. I've clipped the instructions separately. I'll further clip all of them together. That is the original packet for you, and it will be taken with you into the jury room, as will all of the exhibits. Some of the exhibits are DVDs. I think there may be some other forms of electronic submissions. We will have a computer in the jury room as well as a means for you to display those on a television screen if that's what you desire to do. We're making that available to you. I'm not instructing you that you shall look at them. They're available to you, and it's up to you to decide whether you want to view them, as it is with the rest of the exhibits, all of which that have been admitted will go back into the jury room for you to access as you see fit. There are 2 additional things I need to do. At the start of this case, I indicated that we would have 12 jurors and 3 alternates. The 3 alternates will not deliberate with you at this time. The 3 alternates were chosen in advance, not by specific identity, but by seat number. Seat numbers were chosen before you ever were called into the jury room, or into the courtroom, excuse me. And those of you who landed in certain seats are the alternates in this case. Those are seats, not the seats you're currently in now, but the seats that you were in at the end of jury selection. Seat 2, Ms. Montoya. Seat 7, Ms. Walker. Seat 13, Ms. Reed. The 3 of you can go back into the jury room with the rest of the jurors, but you're to gather your belongings, and then Mr. Smith will bring you back out into the into the courtroom. I'll have further instructions for the 3 of you at that time. There's to be no discussion of the case while the 3 alternates are gathering their materials. You cannot begin your deliberations until they have left the jury room. Last thing for me to do is swear in Mr. Smith to act as the bailiff. You solemnly swear or affirm under penalty of law that you will, to the utmost of your ability, keep this jury together in some private and convenient place, that you will not permit any person to speak to them, nor speak to them yourself, unless by order of the court, except to ask them if they have agreed upon a verdict, and that when they have agreed, you will return them into court. Ladies and gentlemen, you may retire to the jury room, and I will see the 3 alternates back here shortly.